Attorney Troupis, the circuit court made several findings of fact. Are you alleging any of the findings of fact to be clearly erroneous?
I apologize, Your Honor. We submitted an opposing series of findings of facts, and we stand on those as accurate. And to the extent that they are denied in our findings, I would say we do not agree with the findings made.
Well,
but there was not. I
want to be specific.
Yes, please.
Get hands. Okay, the circuit court made this finding of fact number 34 and 35. The Trump campaign did not allege, and no evidence exists, that a single vote was cast in either county by an ineligible voter who applied via Form EL 122, or that any fraud occurred relating to the use of that form in either county. Are you asserting that that finding is clearly erroneous?
Yes, the first half may be correct. The second half is clearly incorrect. We, as we pointed out in our papers and throughout, there was an assumption that the statute makes that in fact there is fraud, undue influence, and the like in the casting.
We're talking about historical, we're talking about findings of fact, not conclusions of law. For instance, the finding of fact number 66 and 67, the finding of the circuit court was President Trump did not submit any evidence establishing that any voter cast a vote as indefinitely confined who did not qualify as indefinitely confined. In fact, he said, and I looked at the transcript and listened to the hearing, he said, I certainly could not strike those ballots based on an inference which is not supported in fact.
As I just indicated, I believe to another of justices, we in fact did introduce evidence concerning a number of people for which there was a reasonable inquiry would have disclosed it. And I point out that Wisconsin Election Commission has no problem pointing out that if you misstate a witness's address or the like, the clerk is supposed to go out to Google and other places to fill it in. But apparently when it came to this category, they didn't feel the same sort of inquiry was necessary.
One final area of inquiry deals with the Form 122 and what's in the record. As I understand it, on the third day of the Board of Canvassers for Dane County, you submitted an exhibit of names that you thought were illegal voters. That is because of the use of the Form 122. And that among the names that you submitted as illegal votes, of course, was the name yourself and your wife. And so it just seems a little odd that you're standing before us trying to disenfranchise your vote and saying your vote is illegal. Now, I'm not saying that isn't clean hands, but there is a certain voter. I'd go to the nose rather than the hands with that one. What's your response? You're here asserting that your own vote is illegal.
Well, in fact, it is. In fact, it ought not be counted because it does not comport with the statutes. I relied, as many people did, on the clerks to carry out their job and to not give me a form or ask me to do something that was contrary to the statutes. If we think about clerks and we think about their role, I think a good way to think about them is a sentry at the gate. If the sentry doesn't do their job, there are very serious consequences of that. In this case, they did not. They didn't, at least in Dane and Milwaukee counties. And that's the principle. If it affects me like any other lawyer, it affects me. It is what it is.
Counsel, I just